People need to remember that not all of your representatives are out to get you. Many of them are actually working hard to try and restore your rights. These representatives have to deal with these people all the time.
I do not feel that it is appropriate for me or any other person other than the public safety officers on campus to carry a weapon on campus. If I need protection, our current protocol is to contact public safety. I do not want to be faced with protecting myself from a student or anyone else who's carrying a concealed weapon.
If there's a person in there that's a good guy that's shooting a gun, that either my officer or that person is probably not going to survive.
I can't tell who the good guys are and the bad guys are in a critical incident. Don't have time to check permits. Don't know what their reliability level is, how well they shoot, what retention level their holsters are that they're walking around campus that somebody can just snatch away from them.
Putting more guns in the situation statistically is going to increase shootings. That's more guns in an environment will increase shootings. Removing guns at all will not increase. Will make sure that shootings do not happen. Introducing guns into the situation does not solve the issue. What do you mean? What is my source? What do you mean? What is my source? What do you mean? What is my source? Indeed, it is my opinion.
This is a very crucial moment and critical moment in the history of the state of Georgia. As we make this decision tonight, as you make this decision tonight, to equip vigilantes all across the state and make Georgia the most trigger-happy and unsafe state in the union. If you pass this bill, there will be blood on your fingerprints that bleeds from college students who fear going to school in this state. The blood will be on your fingerprints from parishioners who come to worship to find spiritual power, but instead face a congregation of deadly lethal power. The blood will bleed on your fingerprints from travelers who go through the airports in the state to go on vacation, but who are now subject to someone who unknowingly had a gun in their briefcase and created a shooting in the airport.
If those people weren't bad enough, sometimes the people in the pro-rights groups can get in the way also. Here is a video of what happened when House Bill 512 came up in committee in Georgia this year.
I've gotten emails from two different prominent groups, mainly Georgia Carry and Georgia Gun Owners. And Georgia Carry has taken the stance that, and I'm just so you know, I'm focusing on the mandates section that goes towards the mental health issue stuff. I've read through it, and I'm an attorney outside of this. That doesn't mean I know everything. By far, it probably means I know far less. But I've read through the current what we have in front of us today, and it looks as though it just clarifies some of these things and makes it clear and easier to understand what's going on. But yet I have other groups that are saying that we're trying to backdoor folks and take their guns and raise fees. And am I missing something? Because I don't see that. I don't see that. I don't see that's what we're trying to do. I don't see that's our goal. I mean, you don't get much more pro-Second Amendment than me. And so if I'm missing something, please tell me where I'm missing it.
Now the question you have to ask yourself is, how did two pro-gun rights groups send such vastly different emails on the same bill? The simple answer is that one group did not read the bill. The leadership in Georgia Carry spent the weekend on their website showing people where the bill was where they could read it, how to read it and understand it, and asking questions about what people understood and what people didn't like about the bill. Then they asked people to contact their rep and tell them what they thought of the bill. On the other side, Georgia Gun Owners on their website and through email accused the bill of being an inside job done in the middle of the night to take away rights. but didn't give their members any information about where to read the bill or how to find out any real information on it. The main thing to remember is to make sure to read the bill before you contact your reps. Most bills are public within a few days of being introduced. If someone wants you to contact your reps over a current bill, take the time to go and read the bill yourself. Understand how it works and what it means, or find someone that can explain it to you, and then contact your reps. Tell them what you think of the bill. Tell them what parts you do like, what parts you don't like. Inform them of your opinion, not someone else's.
Mr. Representative, the mental health section is not really a mental health. I keep hearing people say a mental health check. This is an inquiry into, under House Bill 512, an inquiry into involuntary hospitalizations. That's what it is. Under federal law, it is a felony for a person who's been involuntarily hospitalized to possess a firearm, and because of that, Georgia law does not permit those people who are federally disqualified for any reason, including involuntary hospitalizations, to possess a firearm. In Georgia, it's true that those involuntary hospitalizations are reported to the NICS system, but it's not true of every state, and certainly we have people moving here from other states as well. But what this section does is narrow the scope of the check that's being performed. There was a concern up here earlier about due process and discretion in the probate judge, and it was pointed out that that is existing law, and under existing law, a probate judge may deny a license to a person who has voluntarily checked themselves in somewhere to get some help with addiction, or a soldier returning from Afghanistan who thinks he might be suffering symptoms of post-traumatic stress disorder or something like that. Somebody who voluntarily seeks help could be disarmed under current Georgia law and is therefore possibly dissuaded from seeking that help. House Bill 512 would remove that sort of incentive to not seek help. It would narrow the scope of the search. It would lower the fees because it's going to take out the background check fee at renewal time, which is $45 starting March 1st. The GBI just raised its fingerprinting price, and $52 if you're using the GAP system. So this $3 fee worry here, we're talking about 1/15 of what House Bill 512 will do in reducing. But the most important provision here is, and we know this because our members have been held up sometimes for many months. And keep in mind that while this says the judge shall require, many of the probate judges are already doing this. I suspect most will be doing this very soon, regardless of what you do with House Bill 512, because of concerns over mental health. And some of the counties are taking months and months to issue the firearms license and are saying, well, we're waiting on this check to come back. Well, House Bill 512 says that there's a presumption that the statement you make on that application is correct, that you have not been involuntarily hospitalized, and it gives a time limit for the first time ever in Georgia law on this particular hospitalization inquiry, which is at line 328 in the version that's there, and it says 30 days. So it'll make sure that that check falls within the same timeline as the criminal background check that's being done. And if I may just point out that the due process consideration is real under current Georgia law, but House Bill 512 is correcting that by making it for involuntary hospitalizations only. And involuntary hospitalizations have due process. If I could just take 5 seconds, and I promise I'll be done. I'll give an example of one set of processes. There are a bunch of them in Title 37 of the Code, but just one of them here is a recommendation from the Chief Medical Officer of the evaluating facility, supported by the opinions of 2 physicians or a physician and a psychologist who've personally examined this person, who then go to the court and say this person's in immediate danger, he needs to be involuntarily committed against his will. It also requires notice of a hearing, where it'll be held, the time and date, a notice that the patient has a right to counsel, the provision of counsel if he can't afford one, a right to be examined by a physician or psychologist of his own choosing. and a right, in the words of the statute, the court shall hold a full and fair hearing unless the hearing is waived in writing by the patient. So House Bill 512, by narrowing the check to the involuntary hospitalization only, will remove that due process concern and make sure that these people are getting due process.
I greatly appreciate that explanation. So to make it clear for me and for everyone else, because I am pro Second Amendment, I am not, by this bill, we are not imposing any hidden fees or new fees. We're actually reducing the fee of renewals.
Well, you are certainly reducing the fee by $45 to $52. The $3 fee that was being mentioned is in current law. You will note that
Right.
It is in line 319. It is not an underlined, meaning it hasn't been added to the code. That's the current fee under Georgia law. Not every probate judge necessarily charges that fee. Many do. The most populous counties do. And I imagine within just a few years, all of them will be doing so.
So one, we're not increasing the fee. Two, we're expediting the process to get your license, correct?
That's correct.
And then third, we're narrowing the scope to involuntary, where before it was just inpatient.
That's correct, yes.
So expediting, no additional fee, and narrowing the scope.
And actually, overall lowering the fee if you ever intend to renew your license. Lowering the fee by 15 times that $3 fee.
I was just wanting to make sure I had clarity from what we have here, because I've gotten well over 1,500 emails from two different groups, and in all honesty, I am asking these questions through genuine concern. I do not want to impose or impede anyone's Second Amendment right. I'm not going to do it, and so I was truly asking their opinion. I mean, as an attorney who's looked over this for Georgia Carry, I was wanting to see if any of these legitimate concerns that were brought to me through 800 more emails had validity to them, and that's where the questions were coming from. If we were imposing hidden fees, if we were prolonging the process, if we were broadening the scope, then it's not something that I would have been able to get behind. But if right now we're narrowing the scope, reducing the fee, and expediting the process, sounds like a good pro-Second Amendment bill.
Representative Hightower, it's actually addressing something that's affecting real people and has affected real people in counties right here that you can see outside of your window. We've had members who've had to wait for months, and the excuse was because of this check in particular. In fairness to Representative Gregory's point, yes, in Georgia, for people who were involuntarily hospitalized in Georgia, it is somewhat superfluous because those are reported to the NICS system, and the NICS check is part of applying for the license. But not all states do that, and we have a lot of people who move here from out of state, and this would permit the probate judge to check for involuntary hospitalizations for that person who has disclosed something like that on the form, which, by the way, it's a crime to lie on that form as well.
I greatly appreciate you being so thorough with your answer. I know the chairman wants us to brevity, but a lot of times some of these things we need you to open it up a little bit and explain it to us, so thank you.